the studio with Jane Curtis with her monthly history program, and we're going to be talking about what people have called bad decisions for the Supreme Court. Let's find out what they are. Jane?
Well, Supreme Court failures began right away. The Supreme Court has done some pretty decent things, but on balance, it doesn't have too good a record.
Oh, dear.
The one thing throughout, when you look back at its historical decisions, it keeps bouncing it forth and back between what's the state's responsibility and what the federal can handle. Mm-hmm. Whatever is convenient for the present sitting in the court, whatever they're in favor of, that tends to be what becomes the one.
That's why the parties fight so over who's going to be on the court.
Well, they just, we had some real cheating recently, where it was, the nomination was not brought before the Senate.
Right. The
leader of the Senate refused to do that. That is an impeachable offense, although less often has anyone impeached a judge or a Senate. Has happened in the past, but not all that often. But another point that has run through the whole thing is how strictly to interpret the Constitution. And everybody says, well, all the justices say, well, we're interpreting it, of course, and strict interpretationists, like Scalia, for example, say, oh no, we have to exactly, and what the words meant then. But nobody has ever brought up the point of, in those days, the gun difficulties, for example, and weapons of mass, mobile weapons of mass destruction, portable mass destruction. But in those days, in the late 1700s, what weapons were available?
A dueling pistol,
dueling pistols, blunderbusses, and some of those old things from the 17th century that you put on a forked stick, and had to stand back and. Well, those were what was available then. So why is it not interpreted saying certainly now you can? That's what it was at that time. So that's what you can have now. You can't have weapons of mass destruction. But that would never go. So it's an example of how the times change. They say they're staying always with the Constitution, but they're not. And they also recognize that, well, yes, it has to be adapted. Times change, things change, but basic principles are not supposed to change.
Yeah, and that's what they really have to look at is the basic.
Decency and so on. And when you get down to looking at case by case, I've read a whole bunch of them, and looking for things here, an awful lot of them have to do with race.
With race?
In one form or another, a racialism.
Right.
And that's not a pretty picture. No. It's been a long time. And some have to do with gender. Mm-hmm. That's not a pretty picture either, although it's been much less in the public eye, much less brought to the fore than some of the others. So what I've done after reading a lot of cases and a lot of commentary is make a chronology here and pick out certain things to mention from each year and show some of these things that have come up. Mm-hmm. I'm not trying to make people never trust the Supreme Court again, but on the other hand, I really think since voting and whom we elect and any pressure we can exert on people we elect to do what we think is right. Mm-hmm. I mean, you look at today on some of the most controversial matters, public opinion, 70–80% one way, and leanings are the other way. Mm-hmm. So this is something we should think about carefully. And I know we're all going to have our viewpoints. We can't help that.
Right.
But in a couple of generations past, they managed to get around that and at least move forward in an acceptable way and keep some kind of standards.
Right.
I think. But the Supreme Court, now, what actually do we have one for? Well, they're supposed to uphold the Constitution. And in a democracy, they're supposed to look out for the rights of minorities. And in some cases, for majorities, like the gender thing, like women's vote. Women are the majority, and yet Roe versus Wade, they're still trying to get rid of that. So,
Right.
But so it kind of cuts both ways. But the, well, they're the top court of appeal, but the most important one possibly of all is that they are the balance of three. And this concept, when it came out, you know, in the, principally in the 18th century, was such an important one. If you have three equal parts in government, you don't have two because they'll slug each other and one will win. You don't have more than that because it'll run into the sand. But you have three and they will control each other. Each has its powers, and they're not supposed to overstep their powers except by consent or an emergency or something like that. And it's not a ganging up thing. It's supposed to be an adult, grown up, keep each one with its power and will balance, and the balls will stay in the air, so to speak. The country will go all right. Well, Justice Marshall was the first one, Chief Justice Marshall, and he lasted until the 1830s, so he was in for a long time. And I looked into him very carefully, and he never really even defined what a citizen is as opposed to a corporation or an organization of any kind. And you see him contradict himself. If we had a moment, I might even read a little of something from that. But that's a kind of basic thing. They must agree on their definition of things, and they don't always. Now, 1857, Dred Scott versus Sanford. And this, the title at least is known to everybody. But the Dred Scott decision, they've been talking about this for a couple of years. And of course, in the 40s and 50s, the slavery question was getting hotter and hotter. But the Dred Scott decision said that no black person could be an American citizen. In other words, it had to be white, and I don't know if it was completely spelled out in the ruling, but you had to be a property owner, you had to be male, you had to be white.
To be able to vote, right.
To be able to vote, that's right. What that decision also did was nullify the Missouri Compromise. And the Missouri Compromise, as the country grew and more states were taken into the Union, this controversy beginning to develop, the slavery, and those who didn't want it saying, well, no, don't let them in. But what they did was to say, they compromised, a temporary compromise anyway, that any time a state wanted to come into the Union, the state had slavery, legal, lawful, full-running slavery, another one had to come in at the same time that was not, that forbade slavery. So this compromise was shaky at best, but in 1857 it was rubbed off the books. No more 1857 there. Now in the 1860s, the slavery question, of course, came to much more of a head, but what happened then, they began to have laws for granting citizenship or, well, equality, not yet, legal equality, not quite citizenship. Because previously, a slave hadn't been counted even as a full person.
Right.
What was it, 2/3 of a person?
Something like that.
So a slave owner acquired, so to speak, a point for himself and a point for each member of the family, and 2/3 of a point for every slave they held.
Right.
Well, this, of course, was not so good. But 1865, when the war ended, they were all declared citizens of the country. And in the following decades or so, that led to some gross excesses. And the carpetbagger phenomenon, rise of things like the Ku Klux Klan, not good. So the Supreme Court, the 13th Amendment and the 14th Amendment said that blacks were citizens and that they were equal under the law. In 1871, they passed a law against Ku Klux Klan meetings. That law was later nullified because it restricted
Meeting, right?
well, yeah, see, silencing. I think it was under the free speech principle that went. But in 1871, the Enforcement Act banned the Ku Klux Klan meetings. But in 1870, what had happened, and I encountered this when I was looking into the women's movements of the time, all males received the right to vote. And this was by the openly racial leaders of the government. And then they discovered they'd shot themselves in the foot because very few black males could and would vote. They still, they didn't want that on the books. It was not nice. And the Supreme Court was letting this happen. In 1875 then came the Civil Rights Act of 1875. On paper, this set things right. It said that everybody, regardless of race, color, not gender, everybody of any race, any color, any background, had full access to public facilities. I mean, to theaters, to churches, to hotels, restaurants, everything, libraries, and this was simply not done.
Right.
And here was a case where the Supreme Court hadn't been, there were no niceties over, well, that's for the states to decide. It was passed as a blanket thing. But what happened, let's see, when did that occur? Well, it began in around 1880, little laws chipping away at that. And some of the decisions that were written, upon the commentary that was written handing down the decision, were pretty open about it. And there were things like, how would you like to go to the beach as a white person and find a lot of black person? And somebody even read up going, how would you like to go as a black person and feel you had to be there and with all these white people hanging around? Nobody could relax. Well, none of this, of course, was good. And the Supreme Court was letting it happen, or not taking action, or action might have been. Now, there was one, as an example now of the kind of pretzeling around they did. In 1883, there was one, several decisions ending in Civil Rights Act of 1875. Now, in this one, the court ruled 8-1. The number of people on the Court of Justices varied over the years, but it settled on 9 people about that time. And an odd number, of course, so that somebody could win. Right. There were times when it was even, and that didn't work. But there's an 8-1 decision that those 2 amendments, the 13th and the 14th, they are making everybody a citizen, do not allow Congress to prevent non-governmental racial discrimination. Now, what's that? That means anything to do with the government. Oh, yes, we can prevent that. But anything in the states. See, here are the states. Well, the states get to decide that. Yeah. So you see, the principle has flipped over. Now, human beings are human beings, but it went a little far on some of these. They said Congress lacked the constitutional authority under the 14th Amendment to grant equal protections under the law to blacks, stating that only states and local governments could do that. And by the way, they declared the Enforcement Act of 1871 unconstitutional. So that meant the Ku Klux Klan could meet, bloom fresh and fair once again and get away with it all. 1890, Louisiana is an example of one of the states that passed their own laws, getting it illegal to have more than one race in a railroad car. You had to. separate them, either not allow any other colors or separate in a separate car. That was not allowed. Separate but equal, and pretty well gone by the board by that time. Plessy, no, that was 1896. Plessy versus Ferguson. That is supposedly a very famous case in law school that students study hard. Separate but equal, the separate but equal law really just wasn't working. Well, in 1905, here was an example of a case where a state did pass a law, and the state passed a law that the legal number of hours you could work per day was 10. And this bakery owner, I don't know if he was an individual or if it was a string of bakeries or what, but this bakery owner, Lochner, sued New York, saying that I can keep people working day and night if I want to. You know, that's, and went to the Supreme Court. Private enterprise and so on. That's his business. They work for him. They either don't work for him or they do that. Well, there's some more cases on that order. Coming in between is industrialization, you know, and marketing, and trying to squeeze more profit out of it. Now, Hammer versus Degenhardt. This one was a pretty gross one too. This regarded child labor. Now, the government had said, well, we can control, there were earlier liquor laws, and there were postal things and so on, where the federal government legislated for everybody. But in this case, they said it was a state matter if child labor could be used in intra-state, not only interstate, but within the state. They got to call the shots. So child labor, go right ahead. Mm-hmm. And you sort of think that that might have been one that they'd boggle over. There was a lot of argument at that time, again, about votes for women. Finally in I think it was actually passed in 1919, but not put through until then. In the 20s, you had laws, again, favoring big business, as they had in the 1870s, 80s, 90s, industrialization. I mean, after all, a lot of these were millionaires on the Supreme Court, some very, very wealthy people. Look at Justice, was it Holmes? Well, there were others. But in 1927 came a case called Buck versus Bell. And this one alleged that certain people should be sterilized because they were mentally incompetent. Mm-hmm. They should not be allowed to reproduce. And this thought in itself is rather gross. But what they did, they had a woman, and this woman, through no fault of her own, was obliged to bear a child. And the woman herself, they looked into, and she didn't have any education. So now, in parts of this case, there are going to be 3 people involved. Parts of it, they did test them, and they were mentally competent on a simple level, but not mentally incompetent. Right. They knew how to work in society and deal with people and all that. But they then checked on her mother. And her mother, they declared to be mentally incompetent. She'd been a sharecropper or something, or even lower. And so when you had these 3 women then, they declared them all to be mentally incompetent and should be sterilized. So they can't put any more in the world. This passed. This passed. 1927, Buck versus Bell. Moving along here in the 30s, well, by the time the World War II came along, there was a case called Koremitsu versus the U.S. And this was internment of Japanese. And there were people who were a second, I think even third generation or more from that. An echo of that had happened when the Chinese were treated as non-people, the Chinese workers. And we looked into that, in fact, a little bit in one of our previous things here about laws. But yes, in fact, I know somebody who is son of we had a family who was actually interned in World War II. They were sent to Arizona. And they just led sort of they weren't whipped and beaten and deprived of food or anything, but their whole life was just put on hold.
Yeah.
And
They
they
had to give up their businesses and their homes.
and they were, in essence, treading water for those years. But of course, the insult of it too. There's a Spencer Tracy movie. We got part of the theme of that is a Japanese who gave his life for this country in the war, but his father was murdered and hounded off the land. You know, not nice things. Now of course, they may overdo the pathos a little bit, but the principle of it is there, and the court let it happen. Let it happen. That was during the war. Now, famous Brown versus Board of Education in 1954. This one, in no uncertain terms, overturned Plessy versus Ferguson, which was the separate but equal. The court stood still for it. We have a couple more things I want to say if we can here. The seizing of private property for developers' rights. There are a number of cases I saw on that. One of them was 1992, and this is not such ancient history. Lucas versus South Carolina Coastal Commission. This clever developer snapped up a bunch of properties on the beach in South Carolina. And as you know, that's wonderful territory.
As long as the hurricanes don't take it.
Well, you have to reckon with the hurricanes. But there are measures being taken for a long time to try to hold that back. They're not going to eventually succeed. But that's where the Wright brothers, those wonderful dunes, where the Wright brothers did their thing. But the developer bought these vacant lots. The state didn't want this to happen. They didn't want it developed. They didn't want beach erosion. I mean, tourism was, so they weren't entirely disinterested motives, but they were definitely thinking of not just ruining this beautiful area. So they passed a law, or is referred to as passed an act. I don't know if there's a difference. I don't think there is in this case against it. Went to the Supreme Court. And you know what the reason was why the Supreme Court overruled the state and said, yes, the developer can do it. Total destruction of an economically viable use. Now, economically viable, this is a lot of, gobbledygook. But this simply meant you couldn't deprive these people from making money, ruining the land and rushing off somewhere else. You couldn't deprive them of that. It's economically viable. You can do something with it. You can take the beautiful valley and put a factory in 23 rows. You can do that. Well, so much as, discussion or compromise. In fact, in that, I didn't get to read that actual case ruling on it, but it said it went on to express anti-environmental views. It's there to be used.
And that was before the big environmental push, yeah.
Well, 92,
it was beginning,
they were aware
but
of it.
Wasn't,
it was beginning, yeah. I think the 80s or the early 80s were when it first came out. And there was a deadline, in which people didn't like. There were, starting in 2014, there were more decisions along those lines. And there were Supreme Court decisions against the, well, I guess you would, the equitable rule. And now this, I want to read something on this. This was a Davila versus Davis. Davila was a prisoner in jail, and I think it was a capital crime. But during the trial, he lost, and it was appealed. It was appealed twice, I think. and both appeals were lost, and it was appealed to the Supreme Court. The reason why that was being put forward was that his counsel had not brought up certain sticky legal points that you have to bring up then and there, you see, or it can't be tried by a federal court. Well, these were all just left undone. And what I have here, the court's decision now prevents federal courts from reviewing or granting relief on a meritorious claim, that is, on a legitimate claim, if the appellate counsel, if the defendant's lawyer failed to raise that claim, and then after he was convicted, if that legal setup did not raise the claim again, they just would be ineffective. Among the reasons provided for failing to bring up these claims of appellate counsels not doing anything were the burden upon the system. Oh, if we let this happen, there'll be a burden on the system flooding the federal courts with claims like this, and with claims and the intrusion on state sovereignty by disrupting a conviction and sentence. Now that really, it seems to me that any lawyer, if it's a bad lawyer or an unpleasant person, should perhaps say, well, we disagree and so on, but what is the law there for? Comes a question. And what Supreme Court justices, now you had another case of that, where in Texas, employees' failure to exhaust all remedies before going to the Equal Employment Constitution, but they proved only that they rejected it, and they said then the employer can always waive it and say, well, this doesn't apply because it wasn't raised on time. You did not do it on time, and therefore, forget about it.
Forget it.
The employer wins. I think something like that happened didn't it, with the religious question in Toys R Us? Some employees, well, we won't go, that's another example, however. The Supreme Court decision on 1 July, the latest one I had to quote here, blocked the Trump administration from putting a citizenship question back on the sentence. And John Roberts, the present Chief Justice, voted with a majority on that one. Putting a question back on the sentence. Now, the object of the question was to determine whether there were people here how many people here were not citizens, assuming they would tell the truth and assuming they would reply at all, respond at all to it. Is that right or is that wrong? Well, again, a lot of them went back to the Constitution and said, no, that's wrong. But it's almost impossible to tell, and it's almost impossible to get a truly impartial person.
Oh, yes.
And that's why compromise is so important on these things. And most of these had
we're down to 1 minute.
A lot of room for compromise. You don't, I think, with a question like child labor. Maybe under very special circumstances, training could come under that if somebody's profiting from it. But it's a question we really should think about when we vote. And it has become, I'm afraid, mostly politics.
Of course, we don't vote for the Supreme Court.
No, but we vote for those who determine.
We vote for the president, and we vote for the
Senate.
Senate.
Yes.
So it's those people who select the Supreme Court.
Exactly.
So that's where we have to put our effort.
Now, you do usually have a swing voter. And the present Chief Justice, who counts as a conservative, has been a swing voter in a couple of things. And I know in the past, this has also happened.
Okay.
But it doesn't happen, otherwise they're pretty hard rock, like Justice Thomas on the one, and Ruth Bader Ginsburg is pretty firmly on the other. Oh, she made it a point that you act civilly on the Kavanaugh thing. The other justices were queried, how are you going to treat him?
Okay, we've got to move on.
Yeah, and they said we've got to be civil.
Right. So
Yes.
remember, as you're voting, that your vote counts as to how this country is going to be run and how the Supreme Court interprets that Constitution.